Chapter 8. Original Bills in Chancery. Article 1. Original bills generally considered. 132. Suits in Chancery contrasted with actions at law. A litigation in the Chancery Court is properly termed a suit, while a contest in a court of law is properly denominated an action. The party who institutes a proceeding in a court of law is ordinarily called plaintiff, while he who begins a suit in a court of Chancery is generally called complainant. The person sued is called defendant in each court, unless he responds to a discovery in Chancery, in which case he is sometimes denominated respondent. In a court of law, an action is begun by filing a bond for costs and suing out a summons. But in a court of Chancery, a suit is commenced by filing a bill, the cost bond not being essential to the beginning of a suit, as it is in the circuit court. In a court of law, the first pleading is a declaration filed at the return term, couched in formal and technical phraseology, full of bombastic verbosity, and teeming with blood-curdling descriptions of imaginary barbarities inflicted by the wicked defendant upon the innocent and outraged plaintiff. While in Chancery, the bill is filed before the subpoena issues, and is ordinarily a plain statement, in ordinary language, of complainant's rights in the premises, and of their retention or violation or threatened violation by the defendant. Indeed, a bill would be correctly phrased which described the grounds of suit in the manner and language which one unprofessional person would use in writing about them to another. And such was the character and frame of bills in the early history of the court. In an action at law, the evidence is mainly given by witnesses examined orally in open court, whereas in a Chancery suit, the evidence is mainly contained in depositions taken in vacation. In an action at law, the issues of fact raised by the pleadings are ordinarily decided by a jury under instructions by the judge, while in Chancery the issues of fact are ordinarily heard and determined by the chancellor. A court of law regards forms, rules, and precedents, while a court of Chancery regards the circumstances of the case, ignores forms, and prefers good reason and good conscience to rules and precedents. In an action at law, the decision is termed a judgment, ere it either awards a sum of money or the possession of property to the plaintiff, or taxes the plaintiff with the costs of the suit. While the decision in a Chancery suit is called a decree, and it may not only award money or property to one or more of the complainants, but may at the same time award money or property to one or more of the defendants, or may require a party to do some particular act, or may prohibit him from doing some particular act, and may tax any of the parties with the costs, or may divide the costs among the parties. In an action at law, all property to satisfy a judgment is sold by the sheriff under an execution, and he receives and pays over the money. But in a Chancery suit, the sales of property, and especially real property, are usually made by the clerk and master, and confirmed by the chancellor, and the proceeds of the sale are paid out by the clerk and master. In an action at law, an equitable interest in property is not cognizable, and an equity cannot be levied on or sold, whereas in Chancery equitable interests are dealt with, and may be sold or transferred or converted into a legal estate. And the reliefs the two courts grant are very dissimilar. Courts of law have a distinct form of action to redress each wrong and assert each right, whereas in Chancery several wrongs may be redressed and several rights asserted in one and the same suit. Thus, in the same suit, the Chancery Court may 1. Stay waste. 2. Impound the proceeds of the waste. 3. Award damages for the waste committed. 4. Adjudge the land to the complainant. 5. Give him a decree for back rents. And 6. Put him in possession of the property. Whereas a law court would require 4 different actions, and an injunction in Chancery besides, to accomplish the same results. In an action at law, the plaintiff must sue for either property or money. In a suit in Chancery, the complainant may sue for both the property and its money value in the alternative, and if he failed to get the property, the court will, in a proper case, award a money equivalent. In an action at law, you get what the law allows. In a suit in Chancery, you get what is just and right, according to equity and good conscience. The law may be right, equity is right itself. 133. How a suit in Chancery is commenced. A suit in Chancery is commenced, 1. By bill or petition, addressed to the Chancellor of the division in which it is to be filed, and specifying the particular court in which it is to be filed. Or 2. By motion in open court, where that mode of procedure is allowed by law. 1. By bill or petition. A bill is a complaint in writing addressed to the Chancellor, containing the names of the parties complaining and complained of, and their respective places of residence, and setting forth a clear and orderly statement of the complainant's rights, and how and wherein those rights have been denied, interfered with, or violated by the party complained of, and concluding with a prayer for process to bring the latter party before the court to answer the complaint made, and a prayer for appropriate relief. A bill is sometimes called a petition, especially when filed to obtain 1. A divorce, 2. Dower, 3. A partition of land, 4. A sale of lands for partition, 5. A sale of lands to pay a decedent's debts, 6. The removal of a trustee, 7. A mandamus, 8. A habeas corpus, and 9. An inquisition of lunacy. A petition, however, is ordinarily a written statement made to the Chancellor during the progress of a suit, in order to bring before the court, or the Chancellor, some matter connected with a suit affecting the petitioner's rights, and not otherwise sufficiently appearing, or to obtain some relief in the cause not otherwise obtainable. When a suit is commenced by petition, the petition must contain the names and residences of the parties, and a sufficient statement of the facts to show that the petitioner is entitled to relief, and must pray for process, 6, and for relief. 2. By motion. Suits commenced by motion in the Chancery Court are conducted in a summary way, without formal pleadings, the motion being entered on the minutes of the court. This entry is in the nature of a pleading, and should contain sufficient facts to give the court jurisdiction, and to authorize the judgment. As, however, all ordinary original suits in Chancery are commenced by bill, the nature, substance, and forms of bills, and the practice and pleadings consequent on the filing of a bill, will first be considered, and suits commenced by petition and by motion will be treated of hereafter. The party who institutes the suit is generally termed the complainant, because he complains of some wrong done him. The party against whom the suit is instituted is called the defendant, because he defends against the complaint made. 134. Necessity and object of pleadings. In every system of jurisprudence, some forms of proceeding must be established to bring the matters in controversy between parties before the tribunal by which they are to be adjudicated. These forms of proceeding are devised in order that the litigants may have a fair opportunity of presenting their respective sides of the controversy, and to enable the court to determine the questions in issue with accuracy and dispatch. The written complaints made by the complainant, and the written defenses made thereto by the defendant, are termed pleadings, and to exhibit the present system of equity pleading in Tennessee is one of the main purposes of the present treatise. Such portions of the old system of pleading as are obsolete will be wholly omitted, and much of that which is unnecessary or unimportant mainly disregarded. 135. General nature of a bill. A bill is a written statement of such matters as the complainant's desires to bring to the attention of the court. These matters must be such as are within the jurisdiction of the Chancery Court. That jurisdiction generally extends to the final decision of the subject matter of the suit, but sometimes it is only ancillary to the decision of a suit pending in the same court, or of a suit brought, or to be brought, in another court. Sometimes it is merely of a precautionary or preventive nature, to avert a meditated or threatened wrong, and sometimes it is merely to require that the parties really interested in a controversy should be compelled to litigate their rights, without peril or expense to a mere stakeholder having no interest therein. The bill may either complain of some injury, which the party, exhibiting it, suffers and pray relief according to the injury, or without praying relief, it may seek a discovery of matter necessary to support or defend another suit, or it may seek to preserve or perpetuate testimony, or it may complain of a threatened wrong or impending mischief, and stating a probable ground of possible injury, It may pray the assistance of the court to enable the party exhibiting the bill to protect or defend himself from such wrong or mischief whenever it shall be attempted or committed. Or it may relate to some defect in a pending suit in the same court, or may seek to introduce some new or additional matter into a pending suit, or to obtain the benefit of, or change, or reverse the proceedings in, a pending suit. 136. Different kinds of bills. Bills in Chancery are of two general kinds. 1. Original bills, and 2. Bills not original. Original bills are those which relate to some matter not before litigated in the same court, by the same persons, standing in the same interest, and making the same allegations. Bills not original are those which relate to some matter already litigated in the same court by the same parties or their privies, but which seek to make some addition to, or to obtain some benefit from the original bill, or to supply some defect in it. There is another class of bills, which is of a mixed nature, and partakes of the character of both of the others. Thus, for example, bills brought for the purpose of cross-litigation, or of controverting, or suspending, or reversing some decree or order of the court, or of obtaining the benefit of a former decree, or of carrying it into execution, are not considered as strictly a continuance of the former bills, but in the nature of original bills. And if these bills require new facts to be stated, or new parties to be brought before the court, they are, so far, strictly of the nature of supplemental bills. For all the objects of the present work, this last class may be treated as included in that of bills not original. 137. Original bills. Original bills are divided into those which pray relief, and those which do not pray relief. Original bills praying relief are subdivided into two kinds. 1. Bills praying the decree or order of the court, touching some right claimed by the party exhibiting the bill, in opposition to some right, real or supposed, claimed by the party against whom the bill is exhibited, or touching some wrong done in violation of the complainant's right. This is the most common kind of bill. 2. Bills of interpleader, where the person exhibiting the bill claims no right in opposition to the rights claimed by the persons against whom the bill is exhibited, but prays the decree of the court, touching the rights of those persons, for the safety of the person exhibiting the bill. Original bills, not praying relief, are also of two kinds. 1. Bills to perpetuate the testimony of witnesses, or to examine witnesses de benias, and 2. Bills of discovery, technically so called. That is to say, bills for discovery of facts, resting within the knowledge of the party against whom they are exhibited, or for the discovery of deeds, writings, or other things in his custody or power, and praying no relief on the merits. 138. Bills not original. Bills not original are either an addition to, or a continuance of, an original bill, or they are for the purpose of cross-litigation, or of controverting, or suspending, or reversing some decree or order of the court, or of carrying it into execution. The former kind includes 1. A supplemental bill, which is merely an addition to the original bill, to supply some defect in its frame or structure. 2. A bill of reviver, which is a continuance of the original bill, to bring some new party before the court, when by death or otherwise the original party has become incapable of prosecuting or defending the suit, and the suit is, as it is in equity technically called, abated, that is, suspended in its progress. 3. A bill both of reviver and supplement, which continues a suit upon an abatement, and supplies defects which have arisen from some event subsequent to the institution of the suit. Bills, not original, for the purpose of cross-litigation, or of controverting, suspending, or reversing some decree or order of the court, or carrying it into execution, are 1. A cross bill exhibited by the defendant in the original suit against the complainant in that suit, touching some matter in litigation in the first bill. 2. A bill of review, which is brought to examine and reverse a decree made upon a former bill, at a former term of the court, and for that reason, not subject to a change on a rehearing. 3. A bill to impeach a decree upon the ground of fraud. 4. A bill to suspend the operation of a decree in special circumstances, or to avoid it on the ground of matter, which has arisen subsequent to it. 5. A bill to carry a decree, made in a former suit, into execution. 6. And lastly, a bill partaking of the qualities of some one or more of these bills, such as a bill in the nature of a bill of reviver, or in the nature of a supplemental bill, or in the nature of a bill of review, and others of a like character. Article 2. Frame of an original bill. 139. An original bill generally considered. An original bill is a written statement addressed to the Chancellor of the Court in which it is to be filed, setting forth facts and circumstances, which, if true, show that the complainant is entitled to the assistance of the court in obtaining the relief he seeks against the defendant or defendants, and praying for such assistance and relief. The bill sets out the complainant's rights, shows wherein those rights have been injured, denied, or withheld by the defendants, makes out a case within the jurisdiction of the court, and invokes the court to exercise that jurisdiction by requiring the persons complained of to do what in equity and good conscience they ought to do towards the complainant. Every bill must show clearly on its face: 1. That the complainant has a right to the particular relief he seeks, or to some other relief. 2. That he has this right as against the defendants. And 3. That the court has jurisdiction to enforce this right. If the bill is defective in either of these three essentials, the defendants may have it dismissed. Every bill should clearly set forth a state of facts showing not only that the complainant has a right to the relief he seeks, but that every defendant has 1. A claim, interest, or title in or to the subject matter of the suit, or 2. Is in some way illegally interfering with or withholding complainant's rights or property, or 3. Owes the complainant a debt or duty cognizable in a court of Chancery. 140. What facts must be alleged in a bill? Every bill must contain a statement of facts showing that complainant is entitled: 1. To equitable or legal relief, 2. In the court in which the bill is filed, and 3. Against the defendant charged. In the language of the Code, the bill should contain a clear and orderly statement of the facts on which the suit is founded, without prolixity or repetition, and conclude with a prayer for the required process and appropriate relief. This statement of facts should contain everything necessary to entitle the complainant to the relief he seeks, and should omit everything that is immaterial or irrelevant. Nothing should be averred except what is necessary to be proved, and nothing should be omitted which is essential to sustain the case. The test of the sufficiency of the averments in a bill is: would complainant be entitled to the special relief he prays? If all the averments should be established by proof, and a test of the materiality of a particular averment is, can the bill be fully sustained as to the special relief sought if the averment is not proved? Where, however, there is any doubt whether a particular averment is necessary, the pleader should insert it. And it must always be remembered, in drawing a bill, that everything which is intended to be proved must be alleged, and that nothing can be proved which is not alleged. No facts are properly put in issue by the complainant unless charged in the bill, and as a consequence, no proof can be offered by the complainant as to any fact, however material it may be to his case, unless such fact be stated in the bill, or unless the defendant sets it up in the answer. The court cannot notice matter, however clearly proved, as to which there is no allegation or issue in the pleadings. A fact, neither alleged in the bill nor stated in the answer, is therefore not an issue, and cannot be considered by the court, although essential to complainant's success and fully proved. Courts can notice neither allegations of matters not proven, nor proof of matters not alleged. It is a general rule that whatever is essential to the rights of the complainant, and is necessarily within his knowledge, ought to be alleged positively and with precision. On the other hand, the claims of the defendant may be stated in general terms. And if a matter, essential to the determination of the claims of the complainant, is charged to rest in the knowledge of the defendant, or must of necessity be within his knowledge, and is consequently the subject of a part of the discovery sought by the bill, a precise allegation thereof is not required, If, however, sufficient facts appear on the face of the bill to entitle the complainant to some relief, relief will be granted appropriate to the facts, even though the bill be inartificial, the terms used untechnical, and the relief prayed not specific. 141. How facts must be alleged in a bill. The bill should state the complainant's cause of action with accuracy and clearness, specifying the rights of the complainant, the injury or grievance of which he complains, and the relief which he asks of the court. There must be such certainty in the averments of the facts upon which the bill is founded, that the defendant may be distinctly informed of the nature of the case which he is called upon to meet. The material facts ought to be plainly, yet concisely alleged, and with all the essential circumstances of time, place, manner, and other incidents. If title deeds or other instruments are referred to, they should not be set out in full, but only the substance of such portions as are necessary to a right understanding of the real matters of the bill. It is not a sufficient allegation of a fact in a bill to say that one of the defendants alleges, and the complainant believes the statement to be true. For the defendant may allege that which is quite false, and the complainant may believe it to be true. But the fact should be positively alleged. It is sometimes said that a bill in Chancery should be as certain and precise as a declaration at law. But the proposition is not strictly correct, the same decisive and categorical certainty not being required in a bill. Nevertheless, a bill should set forth a distinct and clear cause of action, entitling the complainant to the relief he prays. All allegations should be positive, and those made on information and belief should be so stated. An allegation that complainant is informed so and so, or that complainant believes so and so, or that complainant is informed and believes so and so, is not sufficient. Complainant must go further and allege the facts directly, saying that complainant is informed and believes, and so charges, that the fact is so and so. But although a general charge is insufficient, yet it does not follow that the complainant in his bill is bound to set forth all the minute facts. On the contrary, the general statement of a precise fact is often sufficient, and the circumstances which go to confirm or establish it need not be minutely charged, for they more properly constitute matters of evidence than matters of allegation. Where a bill, however, charges fraud, accident, or mistake, or attacks a stated or settled account, or seeks the reformation, rescission, or re-execution of a contract, or attacks a judgment or decree, or prays an injunction or a receiver, it should set forth the circumstances and particular facts on which the relief is sought, and general charges of error or wrongdoing, or the use of general averment, is not sufficient, as will more fully appear in the next section. 142. Necessity for fullness and particularity in alleging the facts. Every fact essential to the complainant's title to maintain the bill and obtain the relief must be stated in the bill, otherwise the defect will be fatal. For no facts are properly in issue unless charged in the bill, and of course no proofs can generally be offered of facts not in the bill. Nor can relief be granted for matters not charged, although they may be apparent from evidence. For the court pronounces its decrees secundum allegata et probata. The reason of this is that the defendant may be apprised by the bill what the charges and allegations are against which he is to prepare his defense. If the rule were otherwise, the defendant would not only not know what charges he would be required to meet, but the complainant, by thus failing to inform the defendant, would be taking advantage of his own wrong. Besides, the court has no jurisdiction of any matter not contained in the pleadings. And if the chancellor should assume to make an adjudication not justified by the pleadings, his decree would be coram non judice, and void on the face of the proceedings. And this would be so, even though the facts proved would have abundantly supported the decree had there been pleadings justifying the proof. In drawing bills, it must be kept in mind that there is a difference in the degrees of particularity required between 1. Bills praying ordinary relief obtainable under the concurrent jurisdiction of the court, and praying for ordinary process, and 2. Bills praying for extraordinary process, or charging fraud, or assailing presumptions. 1. Where relief obtainable at law is prayed. In eases of concurrent jurisdiction, The allegations of the bill will resemble those in a declaration in the circuit court, and all that is required is a direct averment of the main facts constituting the cause of action, without any detail of circumstances or allegations of particulars. 3 Such bills need no verification. 2. Where an injunction or a receiver is prayed pour. An injunction and receiver are extraordinary processes that issue before the suit is tried on its merits, and often before the defendant is heard. And therefore, the court requires extraordinary particularity and fullness in the averments of the bill. General allegations of wrongdoing and formal charges of inequitable conduct are wholly insufficient. The particulars and circumstances must be set out, so the chancellor may see for himself that the doings complained of are wrong, and the conduct charged is inequitable, for what may appear wrong or inequitable to the complainant may not so appear to the chancellor. Besides, the chancellor prefers the facts and circumstances of the case to the opinion or conclusions of the complainant. Counsel in drawing such bills should keep in mind that such a bill is not only a pleading, but a special affidavit. As a pleading, formal averments would be sufficient. No verification would be necessary. Only a cost bond required, and only a subpoena to answer would issue. It is on the special affidavit incorporated in the bill that the extraordinary process issues, if issued at all. So the bill, in its twofold nature, should be full, precise, definite, direct, and circumstantial in its averments, and give a detailed statement of the main facts on which the injunction or receiver is prayed. And its allegations should be on the actual knowledge of the complainant, or if on information and belief, should be verified by the informant. The bill must aver that it is the first application for the particular extraordinary process prayed for. 3. Where fraud is charged. What is said in the preceding paragraph about particularity in averment applies fully to bills charging fraud. Fraud is generally established by proof of circumstances, and these circumstances are generally known to the complainant. So the court requires the complainant to set out these circumstances in his bill, not only that the court may know on what grounds the charge of fraud is based, but also that the defendant may know the precise facts he will have to meet in framing his answer and making his proof. A general charge of fraud is nugatory, for fraud is not so much a fact as a conclusion deduced from facts, and a bill charging fraud in general terms as the ground of relief and setting forth no particulars showing the fraud will be dismissed on demur. 4. Where a presumption is assailed. When a presumption is attacked, the proof to overcome the presumption must be exceptionally strong. So, a bill assailing a presumption must be exceptionally strong in its averments and precise in its particulars. A general charge of error in a deed, mortgage, note, or other written instrument, or in a stated or settled account, or in a judgment or decree, is wholly nugatory, and a bill based on such a general charge as a ground of equitable relief is demurrable. The bill should follow up the general charge by setting out in detail the facts and circumstances constituting the error, and if any fraudulent or inequitable conduct in connection therewith is charged upon the defendant, the circumstances thereof must be fully specified, as shown in the preceding paragraph. And in general, a bill seeking to undo what has been done because of error or fraud must specify the particulars of the error or fraud complained of. Extraordinary process includes preliminary injunctions, ne exites, attachments, receivers, publication notices, and appointments of guardians ad litem for persons alleged to be under disability. In these cases, the bill is both a pleading and an affidavit. It is a pleading as to the ordinary process and ordinary relief prayed for. It is an affidavit as to the extraordinary process prayed, and inasmuch as this process is sought ex parte, and before any sort of hearing, so much of the bill as purports to give the grounds for this extraordinary action should be full, precise, definite, direct, and particular in its statements of the facts, and should be based on actual knowledge or on reliable information, and should also explicitly conform to all statutory requirements. All such bills must be sworn to. 143. Complainants must show an interest in the subject matter of the suit. The complainants must show that they have an interest in the matters sought to be litigated. and this interest must be a present, subsisting interest. It is immaterial how small the interest of any of them may be in the subject matter of the suit, if the interest be such that its adjudication will enable the court more completely to settle all the matters in controversy, so as to leave no roots out of which future litigation might spring. The object of a suit in Chancery is not merely to show that the defendant has been guilty of illegal or inequitable conduct, but to show also that the complainant has been injured thereby. The complainant must therefore in his bill show that he has such an interest in the subject matter of the suit as to entitle him to the aid of the court in the protection or enforcement of that interest. And if there are more than one complainant, they must all show themselves in some way interested in the subject matter of the suit. It is perfectly immaterial, however, how minute this interest may be, or how distant the possibility of the possession of that minute interest, if it is a present interest. A mere possibility, or even probability, of a future title or interest will not be sufficient to sustain a bill. The title or interest must be present, actual, and existing. 144 Bill must show a ground of suit. Courts are devised for the relief of persons: 1. Whose legal rights have been withheld or interfered with, or 2. Who have suffered actionable wrongs, or 3. Who are seriously threatened with irreparable injury. They were not instituted: 1. To enable litigious people to harass their neighbors with trivial suits, nor 2. Are they proper places for the airing of supposed grievances, nor 3. The ventilation of supposed wrongs, nor 4. Even real misdoing when the complainant has not himself suffered, or is not menaced with suffering, by reason of such wrongs or misdoing, or is himself in the wrong. According to our Constitution, courts are open to remedy injuries done to one's lands, goods, person, or reputation, and courts of equity sit to administer justice in matters of grave interest to the parties, and not to gratify their passions or their curiosity, or their spirit of vexatious litigation. No man has a right to set in motion the machinery of the courts of justice unless he has a good cause of action, and this cause he must so set forth in his bill that the court may see it. It is in vain that a complainant has a good ground for relief unless he properly sets it forth in his bill and substantiates it by proper proof. It matters not how gross a fraud has been perpetrated, or what relations of trust and confidence have been violated, or what the disability of wards, legatees, distributees, or other persons, or what iniquitous wrongs have been done by the defendant, or what violations of right and justice have been committed. The court will not sustain a bill setting them forth, unless it appear therefrom that the complainant is entitled to some relief against the wrongdoer who is made a defendant. For the court will not go through the form of a suit merely to enable the complainant to show forth the wrongs done by the defendant, and the disabilities and injuries of the complainant, unless it appears, from the facts stated in the bill, that the complainant will be entitled to some relief against the defendant by reason of those facts being proved to be true. The complainant must not only show that he has some interest in the subject matter of the litigation, but that he has such a title to it as against the defendant as gives him the right to sue the latter. Thus, a distributee has an interest in the personalty left by his intestate, yet he cannot sue for its recovery, nor compel a debtor of his intestate to pay the debt to him, because there is no such privity between the distributee and the intestate as will authorize the former to sue a debtor of the latter. The personal representative is the only person who can bring such suits, he only being the privy of the intestate, and entitled to sue for his personality, or for the debts due him. So, a person named as executor has an interest in all the personal property of his testator. But until he has probated the will, he has no right to sue for such property. For until he properly qualifies as executor, there is no privity between him and his testator. 145. Bill must show a case within the jurisdiction of the court. Not only must the complainant be interested in the subject matter of the litigation, and be clothed with such a character as entitles him to bring the suit, and the defendant be liable to the relief sought against him, or be in some way interested in the suit, but it must also appear that the case stated in the bill is within the jurisdiction of the court. Prior to the Act of 1877, increasing the jurisdiction of the Chancery Court, It was often a question of much nicety and perplexity whether the case presented by the bill was one of equitable or legal cognizance. But now it is generally not difficult to determine whether the Chancery Court has jurisdiction of a given case. If the debt is of less value than $50, or is for an injury to person, property, or character involving unliquidated damages, the court has no jurisdiction. But of all other suits it has jurisdiction, provided they are brought in the proper county. The local jurisdiction of the court will be hereafter fully considered. 146. Bill must be brought for the whole matter. A bill must not only be for a subject within the jurisdiction of the court, but it must also be brought for the whole subject. The court will not permit a bill to be brought for part of a matter only, so as to expose a defendant to be harassed by repeated litigations concerning the same thing. It therefore requires that every bill shall be so framed as to afford ground for such a decision upon the whole matter at one and the same time, as may, as far as possible, prevent any future litigation concerning it. It is upon this principle that the court acts in requiring in every case the presence, either as complainants or defendants, of all parties interested in the object of the suit. And upon the same principle, it will not allow a complainant who has two claims upon the same defendant growing out of the same transaction to bring separate bills for each particular claim. Courts of equity discourage the promotion of unreasonable litigation, and for the purpose of preventing a multiplicity of suits, they will not permit a bill to be brought for a part of a matter only, where the whole is the proper subject of one suit. Thus, for example, they will not permit a party to bring a bill for a part of one entire account, but will compel him to unite the whole in one suit, for otherwise he might split it up into various suits and promote the most oppressive litigation. When, however, it is laid down as a rule that the court will not entertain a suit for a part of a matter, it must be understood as subject to this limitation, that the whole matter is capable of being immediately disposed of. For if the situation of the matter in dispute is such that no immediate decision upon the whole matter can be come to, the court will frequently lend its assistance to the extent which the actual state of the case, as it exists at the time of the filing of the bill, will warrant. It is upon this same principle that the court proceeds in all that class of cases in which it acts as ancillary to the jurisdiction of other courts, by permitting suits for the preservation of property pending a litigation in the common law courts, or by removing the impediments to a fair litigation before tribunals of ordinary jurisdiction. In all these cases, it is no ground of objection to a bill that it embraces only part of the matter, and that the residue is, or may be, the subject of litigation elsewhere. The preservation of the property, or the removal of the impediments, is all that a court of equity can effect. The bill, therefore, in seeking that description of relief, seeks the whole relief which, in such cases, a court of equity can give. But if a bill, praying only this description of relief, should disclose a case in which a court of equity is capable of taking upon itself the whole decision of the question, in such a case the bill would be defective in not seeking the relief to which the complainant is entitled. 147. Bill must set up matters in avoidance when, under our former method of pleading in Chancery, if the defendant pleaded the statute of limitations, the statute of frauds, payment, accord and satisfaction, an award, a former judgment or decree, an account stated, a release, a novitian, or any other matter in bar, the complainant could, in his replication, set up matters in avoidance of such defense. If the facts in avoidance of such defense are not set forth, the code having abolished replications to answers, the complainant has now no way of avoiding such defense except by his bill. He, therefore, must disclose in his bill these matters of defense, and then set forth his facts in avoidance of such defense. If the facts in avoidance of such defense are not set forth by complainant in his bill, he will not be allowed to prove them, or if proved, the court cannot consider them, because they are not alleged in the bill. Thus, for instance, if a complainant would avoid a plea of the statute of limitations, he must in his bill give the dates and facts which disclose the bar, and then allege the fact which avoids the bar, such as disability of the complainant, non-residence of the defendant, fraudulent concealment of the cause of action, or a new promise within the statute, or such fact in avoidance, though proved, will not be considered by the court for the reason already given, and the bill will be dismissed. Matters thus set up by the complainant in avoidance of some bar must be proved by him as alleged. 148. Bill in case of a tender by the complainant. When on a bill to redeem, or on a bill in any other case where a tender is necessary, it is alleged that a tender was made, the allegations should specify the date and amount of the tender, and to whom and on what account made, and should aver a willingness and readiness on complainant's part to have paid what was tendered at any time after such tender, down to the filing of the bill, and he should continue and repeat such tender in his bill, and the money or things so tendered should be filed in court along with the bill, or a sufficient excuse given for not so doing. But if the defendant failed to demur to the bill, or to otherwise take proper exception, because the money or thing so tendered has not been duly filed, he would be deemed to have waived such filing. On a bill to redeem, a tender is not necessary when the right of complainant to redeem is absolutely denied by the defendant. 149. Bill must not be multifarious or repugnant. In endeavoring to avoid the error of making a bill not sufficiently particular to answer the purpose of complete justice, care must be taken not to run into the opposite defect of attempting to embrace in it too many objects. The offense against this rule is termed multifariousness. 1. Multifariousness is the improperly joining in one bill several matters of a distinct and independent nature against several defendants. Such a proceeding would be oppressive, because it would tend to load each defendant with an unnecessary burden of costs, by swelling the case with the statement and proof of the several claims of the other defendants with which he has no connection. Besides, the proofs applicable to each would be apt to be confounded with each other, and great delays would be occasioned by waiting for the proofs of one of the parties, when the others might be fully ready for hearing. A bill is not to be treated as multifarious, however, because it joins two good causes of complaint, growing out of the same transaction, where all the defendants are interested in the same claim of right, and where the relief asked for in relation to each is of the same general character. Neither will a bill be deemed multifarious where it states a right to an account from A and B, against whom it has one remedy which it seeks to enforce, and also claims a lien against A for what is due, and seeks that separate remedy against him, for the plaintiff may well in such a bill entitle himself to each. Indeed, the objection of multifariousness, and the circumstances under which it will be allowed to prevail or not, is in many cases a matter of discretion, and no general rule can be laid down on the subject. It is not the number of the parties, nor the intricacy of the claims on the one side or the other, that renders a bill multifarious. It is their disconnection or inconsistency, or the practical inconvenience of considering them together in one suit. Whenever a series of transactions have a common root or origin, and are so connected that it is impossible to tell, in advance of the hearing, what bearing one of these transactions may have upon another, or how the respective parties may be charged in reference to each other, embracing them all in one bill would not make it multifarious. If the interest and liability of the defendants, though separate, flow from the same fountain, or radiate from the same center, or have a common connecting link, the joinder of such defendants and matters in the same suit is admissible. The uniting in one bill of several matters of equity distinct and unconnected, against a sole defendant, is not multifariousness. Bills are not objected to on the ground of multifariousness as much as formally, because if a demurrer for multifariousness is sustained, the court may authorize amendments by directing separate bills to be filed, without new process as to the parties before the court. 2. Repugnancy consists in setting out in the bill two or more causes of action, or two or more grounds for maintaining the same suit, which are inconsistent or contradictory, and tend to nullify each other. Alternative grounds of relief may be set up, and alternative relief prayed, but such grounds or relief must not be antagonistic or contradictory. 150. Bill must be free from scandal and impertinence. Care must be taken not to overload bills by superfluous allegations and redundant and unnecessary statements, or by scandalous and impertinent matter. For if any bill be found such, upon due reference to, and report of a master, the complainant and his counsel will be liable to pay costs. Impertinence is the introduction of any matters into a bill, answer, or other pleading or proceeding in a suit, which are not properly before the court for decision at any particular stage of the suit. One of the ordinances of the Court of Chancery, constituting a fundamental rule of the court, is aimed against this transgression of the good sense, as well as the good taste, of equity pleadings. It declares that counsel are to take care that bills, answers, and other pleadings be not stuffed with repetitions of deeds, writings, or records in here verba, but that the effect and substance of so much of them, only as is pertinent and material, be set down, and that in brief terms, without long and needless traverses of points, not traversable, tautologies, multiplication of words, or other impertinences, occasioning needless prolixity, to the end that the ancient brevity and succinctness in bills and other pleadings may be restored and observed. Much less may any counsel insert therein matter merely criminous or scandalous, under the penalty of good costs to be laid on such counsel. Scandal consists in the allegation of anything, either in a bill, answer, or any other pleading, which is unbecoming the dignity of the court to hear, or is contrary to good manners, or which charges some person with a crime, not necessary to be shown in the cause. To which may be added that any unnecessary allegation bearing cruelly upon the moral character of an individual is also scandalous. There are many cases, however, in which, though the words in the record are very scandalous, and highly reflect upon the party, yet if they are material to the matter in dispute, they will not be considered as scandalous. For a man may be stated on the record to be guilty of a very notorious fraud, or a very scandalous action, and yet, perhaps, without having an answer to this very matter, the party may lose his right. The court, therefore, always judges whether, though matter be prima facie scandalous, it is or is not of absolute necessity to state it. And if it materially tends to the point in question, and is a necessary part of the cause, and material to the case of either party, the court never looks upon this to be scandalous. Were it otherwise, it would be laying down a rule that all charges of fraud are scandalous. However, in cases of mere impertinence, the court will not, because there are here and there a few unnecessary words, treat them as impertinent. For the rule is designed to prevent oppression, and is not to be so construed as to become itself oppressive. Nor will the court, in cases of alleged impertinence, order the matter alleged to be impertinent to be struck out, unless in cases where the impertinence is very fully and clearly made out. For if it is erroneously struck out, the error is irremediable. But if it is not struck out, the court may set the matter right in point of costs. It was to prevent these glaring faults of scandal and impertinence, alike mischievous and oppressive, which might make the records of the courts the vehicles of slander, that the courts of equity, at a very early period, required all bills to have the signature of counsel affixed to them. And if no such signature appears or the signature is not genuine, the bill will be dismissed or ordered to be taken off the files of the court. If either scandal or impertinence exist in a bill, it may be objected to by the defendant in the first stages of the cause, upon a motion to refer it to the master, to inquire into the foundation of the objection. But nothing which is positively relevant to the merits of the cause, however harsh or gross the charge may be, can be correctly treated as scandalous. Thus, for example, in bills to set aside deeds or other instruments for fraud, there are often to be found gross charges in relation to the matter of the asserted fraud. But these charges are not, by any rule of the court, to be deemed scandalous. And indeed, such a proceeding might be dangerous to the cause itself, and prevent a due investigation of its merits. Hence it is that nothing pertinent to the cause is ever deemed scandalous, and the degree of the relevancy is not deemed material. It is obvious that a bill may contain matter which is impertinent, without the matter being scandalous. But if, in a technical sense, it is scandalous, it must be impertinent. According to the ordinary practice of the court, a bill cannot be referred for impertinence after the defendant has answered, or has submitted to answer. But it may be referred for scandal at any time, and even by leave of the court, upon the application of a stranger to the suit. The reason of the difference seems to be that mere impertinence is not in itself prejudicial to anyone. It is but a naked superfluity. But scandal is calculated to do great and permanent injury to all persons whom it affects, by making the records of the court the means of perpetuating libelous and malignant slanders. And the court, in aid of the public morals, is bound to interfere to suppress such indecencies, which may stain the reputation and wound the feelings of the parties, their friends and relatives. A court of chancery is not a register for detraction. 151. Prayers for a discovery and for process. Formerly, the interrogatory part of a bill was one of its main and most distinguishing features. But now that all parties are competent witnesses, and the code allows the complainant to waive the defendant's answer under oath, a discovery is very seldom sought. 1. Prayer for discovery. In the part of the bill, usually called the interrogatory part, the complainant calls on the defendant to make full, true, direct, and perfect answer, upon his corporal oath, to the best of his knowledge, remembrance, information, and belief, to all and singular the matters and charges set forth in the bill, as fully as though particularly interrogated in reference thereunto. The bill also, when seeking a discovery, specially calls on the defendant to answer certain specific matters, and sometimes appends to, or incorporates in, the bill searching interrogatories to probe the knowledge, exhaust the memory, and sift the conscience of the defendant to the uttermost. In this part of the bill, the defendant is also called on to file accounts, statements, deeds, books, writings, and other documents to be used as evidence by the complainant. A defendant, however, cannot be compelled to discover when his oath to his answer is waived. Nor can he be compelled to answer an interrogatory which is not based on some antecedent matter stated or charged in the bill. Nor is he bound to criminate himself or violate professional confidence in his answer. Defendants now, however, being competent witnesses in court, and their oath to their answers being now generally waived, discoveries are seldom called for in bills, it being more satisfactory to take the deposition of the defendants, or to obtain their evidence by cross-examination. The other prayers of a bill are for process and relief. In the old form, the prayer for process came last, but in Tennessee it precedes the prayer for relief. 2. Prayer for process. The code says the bill should conclude with a prayer for the required process and appropriate relief. It is probable that where the defendants are named as such in the commencement of the bill, and the character of the process is manifest from the averments of the bill, a prayer for the required process would not be indispensable, especially if there be a prayer for relief, and that they be made parties by proper process, or even a prayer that they be made parties, or be required to answer. Nevertheless, no risks of this sort should ever be incurred, and the bill should always pray for subpoena as to the resident defendants, and publication as to non-resident defendants. If any extraordinary process is sought, such as an injunction or an attachment, it must be specially prayed for, otherwise it cannot be had. And in such case, the bill must state that it is the first application for such process. If a receiver is desired before answer, there should be a specific prayer to that effect in the bill. However, such a prayer is not indispensable, as a receiver may be appointed on motion at any time during the progress of a cause, on a proper case made out. 152. Prayer for relief. The prayer for relief is generally twofold, first for particular relief, and second for general relief. The complainant should first pray specially for that particular relief appropriate to his case, and then should pray for general relief. But a prayer for some sort of relief, special or general, seems essential, except in attachment bills, and in bills to obtain evidence. The code seems to contemplate that appropriate relief should be prayed, from which it might be inferred that a prayer for general relief was not sufficient. The code provision, however, is rather commendatory than mandatory. Complainant should pray for the precise relief he desires consistent with the facts alleged in his bill, and as he cannot foresee the result of his suit, he may pray specifically in the alternative, always, however, conforming his prayers to the case made out by him in the bill. But when his prayer is in the alternative, its parts must not be antagonistic. Oftentimes a bill has a double aspect. In such cases, an alternative prayer adapted to each aspect becomes necessary. A bill may pray alternately for damages if its primary prayer for equitable relief be not granted, in cases where damages are allowable, as in suits for rescission, specific performance, and injunction. No part of a bill is so difficult to draw as the prayer for relief. Ordinarily, the prayer is the necessary legal deduction from the facts alleged, and it requires a comprehensive intellectual grasp of the whole case to properly formulate the specific reliefs to which the complainant may be entitled. It should, however, be kept in mind that under the prayer for general relief, a complainant cannot obtain a specific relief inconsistent with that particularly prayed for. But while praying for specific relief, the details of the particular relief sought need not be enumerated. The prayer for general relief should never be omitted, as under it a complainant is entitled to any relief not specifically prayed for, appropriate to the pleadings and proof, and not inconsistent with the special prayer. It is said that if there be no prayer for general relief, and complainant is not entitled to the particular relief prayed, his suit must fail, unless an amendment of his prayer is allowed. But where the case made out will justify an amendment, it will generally be allowed on terms. But under a prayer for general relief, a divorce will not be granted. A partition or sale for partition will not be decreed, the bill being for neither. Nor will land be sold in bar of redemption. Article 3. Form of an original bill. 153. Old form of an original bill. What should enter into the substance of a bill has already been considered, and its frame has also been generally described. 1. The particulars entering into the form of a bill remain to be considered. Bills in Chancery were formerly longer and more technical than at present, and contained 9 formal parts. 1. The direction or address, indicating the court in which it was to be filed. 2. The introduction, containing the names, description, and residence of the complainants, and the character in which they sued. 3. The premises or stating part, which detailed the facts and circumstances of the complainant's case, stating the wrongs complained of, and by whom done. 4. The confederating part, which alleged a combination between the defendants and others unknown against the complainants in order to injure and oppress them. 5. The charging part, which set up the defendants' excuses and the complainant's answer to them. 6. The jurisdiction clause, being a general averment that the acts of the defendants were contrary to equity, and that complainants have no adequate remedy at law. 7. The interrogatory part, which called on the defendants to answer not only the allegations of the bill, but various interrogatories also according to the best of their knowledge, remembrance, information, and belief. 8. The prayer for relief, ordinarily both special and general. And 9. The prayer for process to compel the defendants to appear and answer the bill and abide the court's decree. An examination of one of these old bills will show a vast amount of matter wholly unnecessary, and a needless prolixity in the statement of what was necessary. Originally, however, bills in Chancery were plain, untechnical statements of the matters complained of, 3 such as an ordinary man of business would now write to his lawyer. The modern tendency is toward a plain, clear, and orderly statement of the facts, omitting everything not material, and avoiding prolixity and useless formalities. The following is an old form of an original bill in Chancery. 1. The direction or address to the Honorable Seth J. W. Luckey, Chancellor and C., holding the Chancery Court at Rogersville, for the district composed of the counties of Hawkins, Hancock, Claiborne, and C. 2. The introduction. Humbly complaining show unto your honor your orator, John Doe, and your oratrix, Jane Doe, both residents of Hawkins County. 3. The premises, or stating part. That their father, Henry Doe, formerly a resident of Hawkins County, died intestate in said county on July 15, 1840, and Richard Roe and Robert Roe were duly appointed and qualified as his administrators, and at once entered upon the discharge of their duties as such. The said Richard Roe resides in Hancock County, and the said Robert Roe in Hawkins County. The bill sets out that the estate of Henry Doe deceased was more than sufficient to pay all of his liabilities, that the orator and oratrix are the only distributees, and that 3 years have elapsed since the grant of administration. But the respondents have made no settlement with the clerk of the county court. And your orator and oratrix further show unto your honor that they have called upon the said Richard Roe and Robert Roe to make settlement and pay over to them their respective shares of their said father's personal estate. But so it is, may it please your honor, the said Richard Roe and Robert Roe have failed to make any settlement, or to render to your orator and oratrix any statement or account of their actings and doings as administrators aforesaid, to the very great damage, injury, and loss of your orator and oratrix. And your orator and oratrix further show and charge that said Richard Roe and Robert Roe have or should have in their hands as administrators aforesaid the sum of at least $3,000 for distribution to your orator and oratrix as distributees of their said father's estate. And your orator and oratrix well hoped that the said Richard Roe and Robert Roe would have paid the same over to them as in conscience and equity they ought to have done. 4. The confederating part. But now so it is, may it please your honor, that the said Richard Roe and Robert Roe, administrators as aforesaid combining and confederating together to, and with divers other persons at present unto your orator and oratrix unknown, whose names when discovered your orator and oratrix pray may be herein inserted, and they made parties respondent hereto, with proper and apt words to charge them, and contriving how to injure and oppress your orator and oratrix in the premises. The said confederates sometimes pretend that said Richard Roe and Robert Roe never were administrators of the father of your orator and oratrix. At other times they pretend that the father of your orator and oratrix did not die intestate, but left a will, and at still other times pretend and claim that his personal estate was very small, and that all of it has long ago been applied and consumed in paying lawful claims against said estate. And at the same time said confederates do respectively refuse to set forth and discover what said personal estate consisted of, or the items and particulars and value thereof, and how much thereof they have so applied, and to whom and for what paid, and what has become thereof particularly. 5. The charging part. Whereas your orator and oratrix expressly charge the truth to be that said Henry Doe died possessed of personal estate of value sufficient to pay all his just debts and funeral expenses, and leave at least $3,000 for distribution to your orator and oratrix as aforesaid, and that said Richard Roe and Robert Roe were duly appointed and qualified as his administrators, and took charge of his personal estate as aforesaid, and that he left no will, all of which the said confederates at other times confess and admit, all of which actings and doings, neglects and pretenses, and other conduct on the part of said Richard Roe and Robert Roe and their said confederates, are contrary to equity and good conscience, and tend to the manifest wrong, injury, and oppression of your orator and oratrix in the premises. 6. The jurisdiction clause. In tender consideration whereof, and forasmuch as your orator and oratrix are remediless in the premises at, and by the direct and strict rules of the common law, and cannot have adequate relief save only in a court of equity where matters of this and a similar nature are properly cognizable and relievable. 7. The interrogating part. To the end, therefore, that the said Richard Roe and Robert Roe, and their said confederates when discovered, may upon their several and respective corporal oaths, full, true, direct, and perfect answers make to the best of their respective knowledge, information, and belief, to all and singular the matters and things hereinbefore stated and charged, as fully and particularly in every respect, as if the same were here again repeated, and they thereunto particularly and distinctly interrogated, and that not only to the best of their respective knowledge and remembrance, but also to the best of their several and respective information, hearsay, and belief, answer and set forth a full, true, fair, and accurate account of each and every item of property, including goods and chattels, money, accounts, notes of hand, bills single, bills of exchange, mortgages, or other evidences of debt, by them, or either of them received as administrators as aforesaid. And further, that they set forth and discover on their several and respective oaths as aforesaid, and to the best of their respective knowledge, information, remembrance, hearsay, and belief, an account, item by item, and date by date, of each and every payment and disbursement made by them or either of them, and to whom, and for what, on account of said administratorship. And your orator and oratrix further show, set forth in charge, that said Richard Roe and Robert Roe have pending a bill in your honor's court against one John Doe to foreclose a mortgage by said John Doe, executed to the father of your orator and oratrix, for $1,000, and that said Richard Roe and Robert Roe have removed all of their visible wealth to the state of Kentucky, and are intending speedily to remove thither, and that should they be permitted to leave the state, especially after collecting said mortgage debt, their own debt against them by reason of the premises would be greatly endangered, if not wholly lost. 8. The prayer for relief, and that the said Richard Roe and Robert Roe may set forth each, every and all of the accounts and items whereunto they, and each of them, have hereinbefore been specially interrogated, and that your honor order an account to be taken and stated, showing what property and monies the said Richard Roe and Robert Roe, or either of them, received, and should by due diligence have received, as administrators as aforesaid, and that they be required to pay your orator and oratrix such balance as your honor may deem them liable for by reason of the premises, and that your orator and oratrix may have such further, or such other relief as the nature of their case shall require, and as shall be agreeable to equity. 9. Prayers for process. May it please your honor to grant unto your orator and oratrix the state's writ of ne exit republica, staying the said Richard Roe and Robert Roe, and each of them, from departing into parts beyond this state, and out of the jurisdiction of this court, without leave first had from your honor. May it also please your honor to grant unto your orator and oratrix the state's writ of injunction to be directed to said Richard Roe and Robert Roe, their attorneys, solicitors, and agents, therein and thereby restraining them, and each and every of them from proceeding further in said suit against John Doe, and from collecting said mortgage debt, or any part thereof, or any other debt due and owing to said intestate's estate, without leave first had, and that a receiver be appointed to collect said mortgage debt, and all other debts and property due or belonging to said intestate's estate. And may it also please your honor to grant unto your orator and oratrix the state's writ of subpoena to be directed to the said Richard Roe and Robert Roe, therein and thereby commanding them and each of them on a certain day, and under a certain penalty therein to be inserted, to be and appear before your honor, in said court of Chancery, then and there to answer the premises, and to stand to abide by and perform such order and decree therein, as to your honor shall seem meet and proper, and as shall be agreeable to equity and good conscience, and as in duty bound your orator and oratrix shall ever pray for you. Walter R. Evans, Solicitor. Affidavit and jurat, as in the next form. 154. Present form of an original bill. But now by the code, the confederating part, the charging part, the jurisdiction clause, and other mere formi matter, are required to be omitted, and it is made the duty of the court to discountenance prolixity and unnecessary and false allegations in all chancery pleadings. The result of the statute is that in our practice, bills are becoming less and less prolix, and contain less and less unnecessary matter. Nevertheless, there yet remains in them too much of the old leaven of surplusage and tautology. The following is the proper form of an original bill under our present practice. Form of an original bill. 1. The address. To the Honorable John P. Smith, Chancellor, holding the Chancery Court at Dandridge. 2. The commencement, or caption, or style. John Doe, a resident of Jefferson County, complainant. V.S. Richard Roe, a resident of Knox County. Henry Johnson, a resident of Jefferson County, and John Jones, a non-resident of the state, defendants. The complainant respectfully shows to the court. 3. The premises or statement of the facts. 1. That he and the defendants are the owners in fee of a lot in the town of Dandridge, in Jefferson County, situated on Main Street, adjoining the lot of George Williams on the north, and the lot of Samuel Brown on the south, fronting 100 feet on Main Street, and running back between parallel lines 200 feet to an alley, being lot No. 8 in the registered plan of said town. 2. Said lot has no encumbrances on it, and no one has any interest therein, except complainant and defendants, who each own a 1/4 undivided part thereof. The deed to complainant and defendants, for said lot, made by John Brown, has never been registered. It is in possession of defendant Johnson, who refuses in have it registered. 3. The said lot has a large and valuable mansion house upon it, and all necessary outbuildings, making it very desirable property as one lot. It would be manifestly to the advantage of the parties to have it sold for division, as a partition cannot be made without great injury to all concerned. 4. The prayer for process. 4. Complainant, therefore, prays, first, that subpoena to answer issue against the said resident defendants, and publication be made as to John Jones, who is an infant and a non-resident of this state, and that they be required to answer this bill fully, but not on oath. 5. The prayer for belief. 2d. That the defendant Johnson be required to file said unregistered deed with his answer, that it may be used as evidence, and then be registered. 3d. That a guardian ad litem be appointed for the defendant, John Jones, who has no general guardian in this state, to defend for him. 4th. That said lot be sold, and that the proceeds be divided between the parties to this suit, share and share alike, and that complainant may have such further and other relief as the nature of his case may require. W.R. Turner, Solicitor. Eugene Holtzinger, Counsel. 6. The verification. State of Tennessee. County of Jefferson. John Doe makes oath that the statements in his foregoing bill are true, to the best of his knowledge, information, and belief. John Doe. 7. The jurat. Sworn to and subscribed. Before me this deck. 26. 1-895. G. W. Holtzinger C. and M. It will thus be seen that an ordinary original bill consists, usually, of 5 parts. 1. The address to the Chancellor. 2. The commencement, containing the names, character, and county residence of the complainants and the defendants. 3. The statement of the facts on which the suit is founded. 4. The prayer for process. And 5. The prayer for relief. If the bill seeks a discovery, which is not usual, it might be termed a 6th part of the bill, but a discovery is generally included in the prayer for relief. Each of these parts will be more fully considered. 155. Form of the address of a bill. Every bill and petition must be addressed to the Chancellor of the division in which the bill or petition is to be filed, and should designate him by his name, and give his official character, and specify the particular court in which the bill or petition is filed. Or to be filed it would, however, be not improper to omit his name, and address the bill to him as an officer, giving his official designation, Chancellor, not Judge, and the style of his court. The following is the statutory form of address. The address of a bill. To the Hon. John P. Smith, Chancellor of the 1st Chancery Division, holding the Chancery Court at Dandridge. But an address in the following form would not be improper, especially as it may sometimes happen that the exact name of a chancellor in a distant part of the state, or the number of his division, may not be known, or there may be a vacancy in the office. To the Honorable Chancellor, holding the Chancery Court at Tiptonville. The name of a public officer is in such a case immaterial. The bill is not addressed to the man, but to the officer. The 2 foregoing forms are simple, and should be substantially adhered to in drawing both bills and petitions. 156. Form of the commencement of a bill. After the address, it would seem proper that the names of the parties making the address should first be given, so that the Chancellor might know who the parties addressing him are, and in what character they sue. He should also know who the parties are against whom complaint is made, and whether they are sued in their own right or otherwise. It is the practice, therefore, to set out the names, character, and county residence of all the complainants and of all the defendants, next after the address to the Chancellor. This is not only an old practice, but it is also the statutory practice, and no departure should either be made from it by a pleader or be allowed by the court. For it is not only the statutory practice, but it is the best possible practice, and every departure from it is a confusing innovation, alike annoying to the court, to the defendants, and especially to the clerk. Oftentimes, when the names and residences of the parties are not given next after the address, it is really difficult to fish them out of the body of the bill, and the clerk is sometimes greatly perplexed to know who the parties are, and in what counties they reside. The names, character, and county residence of the parties should be given thus. Commencement or caption of a bill. John Smith, guardian of Henry Jones, a minor, both residents of Knox County. Sarah Brown, a minor, who sues by her husband, George Brown, both residents of Anderson County. Eliza Jones, a minor, who sues by her next friend, Henry Williams, both residents of Knox County. And Charles Jones and James Jones, residents of Kentucky complainants. V.S. Jonathan Watson, administrator of Samuel Jones, deceased, and Isaac Jones and Thomas Jones, residents of Knox County, and Richard Jones, a non-resident of the state, defendants. The complainants respectfully show to the court. Care should always be taken to show in the commencement of the bill in what character the parties sue or are sued. And although this is not absolutely required to be done in this part of the bill, it is, nevertheless, a very convenient practice. But the name and county of each party should invariably be fully set out in this part of the bill, for the reasons above given. The following are additional forms of the commencements of bills. 1. Bill by an infant, lunatic, or married woman, suing by next friend. Sarah Brown, an infant or lunatic or married woman, who sues by John Brown, her next friend, both residents of Scott County, complainant. V.S. Charles Brown, the guardian or husband of said Sarah Brown, a resident of Overton County, defendant. And the heirs, distributees, and assignees of William Brown, deceased, whose names and residences are unknown, and cannot be ascertained on diligent inquiry. The complainant, Sarah Brown, an infant or lunatic or married woman, who sues by John Brown, her next friend, respectfully shows to the court. 2. Bill by a husband and wife. Charles Brown and Sarah Brown, his wife, both residents of Overton County, complainants. V.S. John Brown, general guardian of said Sarah Brown, and Henry Jones and Columbus Jones, his sureties as such guardian, all residents of Scott County, defendants. 3. Bill by a guardian, administrator, or executor. Charles Brown, general guardian or administrator or executor of Sarah Brown or of Sarah Brown, deceased, residents of Overton County, complainant. V.S. John Brown and Henry Brown, both residents of Clay County, defendants. 4. Bill by a creditor on behalf of himself and all other creditors. John Doe, a resident of Knox County, complainant, who sues on behalf of himself and of all the other creditors of John Smith, deceased. V.S. Samuel Smith, administrator of said John Smith, and all the heirs of said John Smith, naming them defendants. The complainant John Doe, who sues in behalf of himself and of all other creditors of John Smith, deceased, respectfully shows to the court. 5. Bill by a county, city, or corporation. The county of Roane, complainant. V.S. The county of Loudoun and J. Duff, trustee and resident of Loudoun County, defendants. The mayor and city council of Nashville. V.S. The mayor and aldermen of Edgefield. The East Tennessee Coal Company, a corporation under the laws of Tennessee, or a corporation organized under the laws of Missouri, and registered in Anderson County under the laws of Tennessee, and whose principal office is kept at Coal Creek in Anderson County, complainant. V.S. The Knoxville and Ohio Railroad Company, a corporation whose principal office is kept in Knox County, defendant. 6. Bill by the State of Tennessee on relation. The State of Tennessee, which sues by George W. Pickle, her Attorney General, or by Thomas A. Nelson, her District Attorney, on the relation of John Doe, a resident of Knox County, complainant. V.S. The Mudville Turnpike Company, an alleged corporation whose chief office is kept in Clay County, and John Doe, a resident of Clay County, defendants. The State of Tennessee, which sues by George W. Pickle, Her Attorney General on the relation of John Doe respectfully represents. 7. Bill by partners. John Smith, James Brown, and Henry Jones, partners in trade under the name of John Smith and Co., residents of Shelby County, complainant, John Doe and David Doe, residents of Lake County, doing business under the name of Doe and Bro, defendants. 8. Bill by a taxpayer on behalf of himself and other taxpayers. 21. John Doe, a resident of Knox County, complainant, who sues in behalf of himself and all other taxpayers of said county, vs. the County of Knox, and Richard Rowe, the county trustee, and a resident of said county, defendants. The complainant, who sues in behalf of himself and all other taxpayers of Knox County, respectfully shows to the court. 9. Bill by a legatee on behalf of himself and all other legatees. John Doe, a resident of Union County, complainant, who sues in behalf of himself and of all the other legatees of James Doe, deceased, vs. Richard Rowe, the executor, Mary Doe, the widow, and Roland Rowe, the heir and distributee of Roland Rowe, Sr., deceased, all residents of Union County, defendants. 10. Bill by the state for the use of a citizen. The state of Tennessee, which sues for the use of John Doe, a resident of Lake County, complainant, vs. Richard Rowe, guardian of said John Doe, and Roland Rowe and Robert Rowe, sureties of said Richard Rowe, on his bond as such guardian, all residents of Lake County, defendants. The complainant, the state of Tennessee, which sues for the use of John Doe, respectfully represents. Some solicitors prefer the following form for the caption or commencement and address of a bill, and as it is substantially the form prescribed by the Code, there can be no legal objection to it. Another form of caption and address. The bill of complaint of Henry Wilson and John Smith, both residents of Hamilton County, and Charles Johnson, a resident of the state of Georgia, filed in the Chancery Court of Bradley County, against George Jones and Sarah Jones, his wife, residents of Bradley County, and William Smith, a resident of McMinn County, to the Hon. S. A. Key Chancellor, holding the Chancery Court at Cleveland. Complainants respectfully show to the court. 157. Form of the premises or statement of the facts. This part constituting in truth the real substance of the bill upon which the court is called to act, requires great skill and judgment to frame it aright, and if it has not the proper legal certainty, the defect, unless removed, may be fatal. The rules as to the proper mode of stating the facts in this part of the bill have already been fully considered. It must be remembered, however, that every material fact, as to which the complainant means to offer evidence, ought to be distinctly stated, for otherwise he will not be permitted to offer or require any evidence of such fact. A general charge or statement, however, of the matter of fact is ordinarily sufficient, and it is not necessary to charge minutely all the circumstances which may conduce to prove the general charge, for these circumstances are properly matters of evidence, which need not be charged in order to let them in as proofs. 25. Nothing, however, can be proved that has not been alleged, and nothing can be decreed that has not been alleged. Neither proof nor prayers are of any avail in the absence of allegations. Nothing can be prayed, proved, or decreed that does not rest on allegations. Allegations are, at once, 1. The foundation of the court's jurisdiction of the case. 2. The notification to the defendant of what is to be litigated. 3. The test of the materiality and pertinency of the evidence. 4. The limitation of the bounds of the controversy. And 5. The justification of the relief granted. The Code requires that the bill should contain a clear and orderly statement of the facts on which the suit is founded, without prolixity or repetition, without averring any formal combination or confederacy by the defendants or others, the insufficiency of the remedy at law, or other mere formal matter. The body of the bill should be divided into paragraphs consecutively numbered, each paragraph containing a separate fact and its special circumstances. Such a division not only generally makes a bill more logical, but greatly facilitates reference to its parts and better enables the defendant to frame his answer. 158. Forms of prayers for process. As there is no set form of the premises of a bill, so there can be no set form of the prayer, for the prayer varies with the premises. But the following forms will indicate the general character of the phraseology used in prayers for process. Prayers for process. 1. Prayer for subpoena and publication. Complainant prays that subpoena to answer issue as to the resident defendants, and that publication be made as to the non-resident defendants, requiring them to appear and answer the bill, but their answer on oath is waived. 2. Prayer for an attachment. That an attachment issue by order of your honor, and be levied on all the above described property of the defendant, and all the other property of the defendant, or on enough thereof to satisfy complainant's said debt, and costs of this suit. 3. Prayer for an injunction. That an injunction be ordered by your honor to issue, to inhibit and restrain the defendant, his agents and servants, from committing any further waste, or destroying any timber, or in any way trespassing upon the tract of land hereinabove described, or from transferring, assigning, encumbering, or removing said property, or from doing the particular act or acts complained of or threatened, specifying such acts briefly. 4. Prayer for an injunction against a suit at law. That the defendant, Richard Roe, his counselors, attorneys, and agents, be restrained by injunction from proceeding further in said suit or execution, and also from instituting any new or other suit for a like purpose in said court, or in any other court, or from suing out any other execution or process on said judgment, without leave of your honor. 5. Prayer for a receiver. That a receiver be appointed to take possession of the said goods, chattels, choses in action, or houses, lands, or other property in litigation, or impounded and attached, specifying such property, and that he be authorized and directed to soil the said personal property, or rent and collect the rents of the said houses and lands, and collect the said choses in action, and that a writ of possession issue to put him in possession thereof, if necessary. 159. Forms of prayers for relief. The forms of the prayers for relief are as various as the forms of bills, and depend entirely on the material allegations of the bills. But a careful consideration of what has been already said about prayers for relief, and of the following forms, will greatly aid the pleader in formulating his prayers. Prayers for relief. 1. Prayer for general relief. That complainant may have such further and other relief as he may be entitled to. 2. Prayer for a guardian ad litem. That a guardian ad litem be appointed to defend this suit for the said Robert Roe, who is an infant without regular guardian. 3. Prayer for an administrator. That an administrator be appointed to administer the estate of said Richmond Roe, deceased, in this court, and that all necessary orders be made and accounts taken for that purpose. 4. Prayer for discovery. That all the defendants, or the defendant, Henry Jones, be required on their several and respective oaths to make full, true, direct, and perfect answer to all and singular the matters aforesaid, according to the best of their knowledge, remembrance, information, and belief, and that they specially answer and set forth, whether here insert the particular interrogatories to be answered. These interrogatories may be in the form usually filed in order to take the deposition of an absent witness, omitting, of course, any caption. 5. Prayer for the production of deeds and papers. That the defendant, Richard Roe, be required to file with the clerk and master of this court the said deed or other writing or book, hereinabove referred to the end that complainant, and your honor, may have due opportunity to inspect the same. 6. Prayer for an account. That the defendant, Richard Roe, set forth in his answer a full, true, and particular account of all monies by him, or his agents or servants, received, collected, or in any way obtained from the business and transactions referred to, or received by him as guardian, administrator, partner, agent, or trustee, and all the rents and profits received, or that might, by due diligence, have been received by him from the tract of land, or house and lot, or business, hereinabove described, and all the timber, trees, notes, accounts, goods, wares, and merchandise, or other property he may have sold, removed, given away, or allowed to be removed from said premises, and that the master be ordered to take and state an account of all the dealings between complainant and the defendant, so as to show the full and true amount due complainant, by reason of the premises. 7. Prayers for a money recovery, that the complainant may have and recover of the defendant the said sum of $600, and interest thereon since the day said debt matured, or recover of the defendant the value of the said work and labor done, and of the said services rendered by complainant as aforesaid, or recover of the defendant the amount due on said note, principal and interest, and also the amount due on said account, and interest thereon, and all the costs of this cause. 8. Prayers for damages, that the complainant recover of the defendant the damages he has suffered by reason of the failure of the defendant to comply with his said contract, or to make good his said covenants and warranty, or to perform his said agreement, or that complainant recover the damages he has sustained by reason of the said breaches of contract of the defendant, or by reason of the quality and quantity of said goods not being as represented, or by reason of said deficiencies in quantity, quality, and value, and also all the costs of the cause. 9. Prayer for sale of land, as that said tract of land be sold to satisfy the demand or debt of complainant, or such decree as your honor may pronounce in complainant's favor by reason of the premises, and that said sale be made by the clerk and master to the highest arid best bidder on a credit of not less than 6, nor more than 24 months, and in bar of all right of redemption, or that said sale be made for cash. 10. Prayer for an account of money or property had and received, and that said defendant or defendants set forth in his or their answer or answers an account of each and every sum of money or piece of property received by him or them, or either of them, or by any other person or persons, by his or their order, or the order of either of them, or for his or their use, or for the use of either of them for, or on account of, or by reason of, or in relation to, said agency, partnership, or other business or matter, and when and from whom received, and for what, or on what account, each and every of said sums of money or pieces of property were respectively received, and how all and every of said sums of money or pieces of property have been respectively applied or disposed of. 11. Prayer for an account of rents and profits, and that the said defendants set forth in their answer or answers a full, true, just, and particular account of each and every sum of money received by them, or either of them, or by any other person or persons by their order, or the order of either of them, as rents, profits, or issues of said land or house and lot, or partnership business, or other business, or any part thereof. 12. Prayer for an account of personal estate, and that the said defendant or defendants discover and set forth in their answer or answers a full, true, just, and particular account of all and singular the personal estate and effects of said testator or intestate, and of every item and part thereof which has come into his or their hands, possession or control, or into the hands, possession or control of any other person or persons, by his or their order or permission, or for his or their use, and that he or they give the nature, quantities, and highest values of each of the items so set forth or mentioned, and how the same have been applied and disposed of, and whether any, and what items have not been applied and disposed of, and why not, and that the defendant or defendants set forth an account of the debts of said testator or intestate, and of his funeral expenses, and whether any and which of such debts and expenses have not been paid, and why. 13. Prayer for the production of deeds and papers, and that the said defendant or defendants set forth in his or their answer or answers a list or schedule or description of each and every deed, contract, book, account, letter, paper, or other writing relating, in whole or in part, to the matters aforesaid, or to any of them in his or their possession or control, and that he or they deposit the same in the office of the clerk and master of your honor's court for inspection and copy, and that he or they account for such of the deeds and see, stating them referred to in paragraph Roman 3 state, which paragraph or paragraphs of the bill, as are not in his or their possession. 160. The signing of a bill. Every bill or petition filed in the Chancery Court must be signed by the complainant or petitioner in person or by his solicitor. A signing on the back of the bill by the solicitor has been held sufficient. The great object of this rule is to secure regularity, relevancy, and decency in the allegations of the bill, and the responsibility and guarantee of counsel that, upon the instructions given to them, and the case laid before them by their client, there is good ground for the suit in the manner in which it is framed. Hence it is that counsel are held responsible for the contents of the bill. And if it contains matter which is irrelevant, impertinent, or scandalous, such matter may be expunged, and the counsel may be ordered to pay costs to the party aggrieved. And this duty has often been enforced by the courts of Chancery. So, where a bill has been filed without authority of the complainant or of a co-complainant, the solicitor will, on due proceedings for that purpose, be adjudged to pay accrued costs in consequence of his unauthorized action. It is not essential to the validity of a bill or petition that the complainant should sign it. It is sufficient if their names appear in the caption 30. Nevertheless, it is much the better practice to require a petition to be signed and sworn to by the parties themselves, and not by their agents or solicitors. 161. Verification of a bill. No bill need be sworn to unless 1. It prays for process of injunction or attachment or ne exit, or 2. Unless it seeks the immediate appointment of a receiver, an administrator, or a guardian ad litem, or 3. Unless it is a bill to sell the property of a person under disability, or 4. To administer an insolvent estate, or 5. To set up lost instruments, or 6. To have an inquisition of lunacy, or 7. To obtain a divorce, or 8. For a mandamus or habeas corpus, or 9. A bill in the name of the state against corporations and usurpers of office, or 10. A bill of interpleader, or 11. A bill of review for newly discovered evidence, or a bill to perpetuate testimony, or to take testimony de bene s, or a bill or replevin. It may be stated as a general rule that whenever a bill or petition seeks some immediate order or interposition of the court, such as an injunction or an attachment or a ne exit, the appointment of a receiver, administrator, guardian ad litem, or publication as to non-resident or unknown defendants, it must be sworn to. But the facts necessary for the appointment of a guardian ad litem or for process by publication may be sufficiently made to appear by a separate affidavit, in which case the bill need not be sworn to, unless its verification is otherwise required. Where there is any reasonable doubt whether a bill should be sworn to or not, it is safer to verify it. But a bill that seeks no process except subpoena, seeks no order or relief until final decree, seeks no interference with parties or proceedings in any other forum, and seeks in no way to interfere with the acts, possession, or property of the defendant pending the suit, need not be sworn to. As a rule, petitions should always be sworn to when they are filed pending a litigation commenced by bill. Petitions which are filed in lieu of a bill, such as petitions for divorce, inquisition of lunacy, mandamus, and habeas corpus, must also be sworn to. But a petition for partition, or for homestead, or for dower, need not be sworn to. 162. Manner of verifying bills. There is sometimes a great looseness and sense of irresponsibility connected with the verification of pleadings. Verification is not a matter of form, but of substance. It breathes into bills, otherwise inert, the breath of life and the soul of truth, and gives them immediate and sometimes far-reaching efficacy. The verification of the bill removes it from the category of apocryphal documents, and for preliminary purposes impresses it with the seal of verity. We have no statute or authorized rule of practice specifying the manner and form of verifying pleadings, but the following form is so generally recognized that it may be deemed adequate in ordinary cases. Affidavits to bills. State of Tennessee. County of Morgan. John Smith makes oath that the statements by him in the foregoing bill are true to the best of his knowledge, information, and belief. John Smith. Sworn to and subscribed. Before me June 1, 18890. W, D, right C, and M. A fuller and better form of affidavit is as follows. State of Tennessee, County of Morgan. John Smith makes oath that the statements in his foregoing bill, made as of his own knowledge, are true, and those made as on information and belief, he believes to be true. John Smith, sworn to and subscribed. Before me June 1, 18890. W, D, weight C, and M. When a bill is sworn to according to the latter form, and especially when it shows on its face clearly what statements are made on the complainant's own knowledge, and what on the information of others, it will have more weight on the hearing of a preliminary matter, such as a motion to dissolve an injunction, or to appoint a receiver, than a bill less correctly drawn, and sworn to on knowledge, information, and belief in an indefinite manner. Sometimes a bill is verified by a solicitor or agent. This should never be done, but in case of extreme necessity, especially by a solicitor. When so verified, the solicitor or agent should make oath to his agency and personal knowledge of the matters stated in the bill, except those stated to be on the information and belief of the complainant. And as to those matters, he should make oath that he believes them to be true. 48. This form is suggested. Affidavit to a bill by the solicitor. State of Tennessee, County of Morgan. E. Young makes oath that he is the solicitor of John Smith, the complainant in the foregoing bill, and that he personally knows that the statements in said bill are true, except those made as on the information and belief of the complainant, and those he believes to be true, sworn to and subscribed. Before me June 1, 18890. W, D, right C, and M. E. Young, 163. Before whom bills must be verified. Bills required to be under oath may be sworn to in the state before any judge, clerk of a court, justice of the peace, or notary public, whose attestation shall be deemed evidence of the fact. They may be sworn to out of the state before a notary public, or a commissioner for this state, whose attestation shall be accompanied by his seal of office, or before a judge or justice of the peace of the state, whose official character shall be attested by the clerk of the court in which the judge presides, or by the clerk of the county court in the case of a justice of the peace. 164. Formal parts of bills. To economize space and avoid repetition, the formal parts of bills in many of the forms in this book are omitted. For the convenience of the draftsman, those parts are here given, and this skeleton bill will be referred to for guidance. The address. To the Honorable, giving the name of the Chancellor, holding the Chancery Court, at stating the name of the county town where he holds the court. The commencement or caption. John Doe, a resident of D County, stating the county. Give the names and county of residence of each of the complainants, and if any sue by guardians or next friends, so state, and give their names and county of residence. For forms of commencements, see ante. 156. Complainant. V.S. Richard Rowe and Henry Rowe, residents of county, stating the name of county. Give the name and county of residence of each of the defendants, and if any of them are minors or of unsound mind, without general guardians, so state. If they have guardians, give their names and residences. Defendants. The complainant respectfully shows to the court the premises or statement of facts. That this part contains the grounds of complaint, giving the facts on which complainant bases his right to a decree against the defendant. Roman 2. That this part sets forth any ground for attachment, injunction, or other extraordinary relief complainant may wish. Roman 3. The prayer for process. Complainant therefore prays. First, that subpoena to answer issue against the said defendants, requiring them, and each of them, to answer this bill. If their oath is waived, add. But their oath to their answer is waived. 2d. That a guardian ad litem be appointed for the minor and non-composed defendants. Sec. 106-108. Omit this, of course, if there be no minor or non-composed defendants. 3d. That an attachment issue against the property of the defendants, naming the particular defendants liable. See 869-873. And especially against the property above mentioned, if any be specified in the bill. Fourth, that an injunction issue against the defendants, naming them and enjoining them from doing the acts referred to in the bill. Specify them. C. 823. The prayer for special relief. Fifth, that here state the special relief desired, consistent with the bill. The prayer for general relief. Sixth, the complainant prays also for such further and other relief as the nature of his case may require. Any extraordinary process is prayed ad. This is the first application for an attachment or an injunction in this case. Signature of counsel. Joseph Story of counsel. James Kent solicitor. Affidavit to the bill. State of Tennessee. County of here insert name of county wherein bill is sworn to. John Doe, the complainant in the foregoing bill, makes oath or affirms that the statements in his foregoing bill made as of his own knowledge are true, and those made as on information and belief he believes to be true. John Doe, jurat to affidavit, sworn to or affirmed and subscribed. Before me, August 24, 1905. James C. Scruggs C. and M. Article 4. Practical suggestions as to the drawing of bills. 165. The relations of the parties to a suit. Whenever two or more persons have relations to, or with each other, various legal and equitable rights and duties arise from the relation J1. And for the protection of these rights, and the enforcement of these duties, courts are established. These relations are those of family, neighborhood, society, business, commerce, and government, and may be divided into 1. Primary or original relations, being those that exist between the original parties to the transaction. 2. Secondary or derivative relations, being those that exist between an original party and the privy of the other original party. And 3. Collateral relations, being those that exist between the privies of the original parties. The principal primary or original relations are those of parent and child, husband and wife, guardian and ward, master and servant, attorney and client, advisor and advised, vendor and vendee, mortgager and mortgagee, landlord and tenant, trustee and beneficiary, personal representative and distributee or legatee, principal and agent, bailor and bailee, partner and partner, tenants in common, principal and surety, debtor and creditor, assignor and assignee, creditor and surety, bargainer and bargainee, and citizen and state. The principal secondary or derivative relations are those existing between one of the original parties to the transaction and the vendee, assignee, executor, administrator, heir, divorcee, widow, or other privy of the other original party. The legal and equitable rights and duties arising from the relations of the parties ordinarily become more complicated in proportion to the distance the parties are removed from the original parties. But as a rule, a privy's rights and duties are the same as those of the person in whose shoes he stands, or to whose rights he succeeds, the principal exception to the rule being in favor of innocent purchasers for value without notice. 166. The general rule of law applicable to the case. No one can draw a logical and concise bill without first considering the relations of the parties to the controversy and the general rule of law applicable to the case, and then alleging the facts necessary to bring the complainant's case within this rule. This general rule of law is often termed, in our reports, the theory of the bill. The clearer this general rule or theory appears to the mind of the pleader, the more logical and concise will be the allegations of his bill. Indeed, the obscurity and confusion and indefiniteness of a bill almost invariably result from the obscurity and indefiniteness of the pleader's conception of the general rule of law applicable to the facts of his case. The law of relations enables a pleader readily to grasp these general rules of law, and thereby make his bills logical and concise, the two principal characteristics of good pleading. To every general rule of law, there are various exceptions, but these exceptions are ordinarily matters to be brought forward by the defendant. In drawing a bill, all matters which are within exceptions to the general rule, and all matters in avoidance, should generally be left for the defendant to allege and prove. The general rule of law arises: 1. Out of the relations of the parties, 2. Out of the rights and duties resulting from those relations, and 3 out of the acts of the defendant in violation of those rights and duties, and 4 it defines the manner and measure of redress to which the complainant is entitled. Hence, a pleader, before beginning to draw a bill, should consider the general rule of law applicable to his client's case, and so frame his bill as to make out a case within the rule, and at the same time not within any of the exceptions to the rule. The most easy and logical way to do this is by keeping in mind the relations of the parties and the acts of the defendant in violation of the duties arising from those relations. 167. Application of the law of relations in drawing a bill. Out of the relation of the parties, certain legal or equitable duties arise on one side, and certain legal or equitable rights on the other. These rights and duties are correlated, the duties owing by one party being the rights owned by the other. A violation of the duties violates the correlated right, and a cause of action arises in favor of the owner of the violated right and against the owner of the violated duty. These correlated rights and duties are, or may be, formulated into general rules of law, the knowledge of which is essential to an adequate comprehension of the ease. When therefore a solicitor is called on to state the law applicable to a given case, he should consider 1. The relations of the parties, 2. The duties arising from those relations, 3. Which of those duties have been violated by the defendant, 4. What remedy the general rule of law applicable to the case provides for such violation, and 5. In what court that remedy can best be enforced. The general theory of every properly drawn bill is 1. That the defendant has done, is doing, or is attempting, or threatening to do, some wrong to, or to withhold some right from, the complainant, and 2. That the court in which the bill is filed has jurisdiction to remedy or prevent that wrong, or to enforce that right. The wrong complained of may 1. Grow out of some act or omission of the defendant, in violation of his duties to complainant, arising from some relation between the parties, or 2. May grow out of some act or omission of the defendant, in violation of some right of complainant, existing independently of any relations. 168. General form of bill where relations exist. Therefore, in drawing H bill based on relations, the first matter to be considered is whether the alleged wrong arises from any relation or not. And the second matter to be considered is, what is the general rule of law or equity applicable to the facts of the case? Having settled the general rule, and ascertained that the case does not come within any of the exceptions thereto, you will, in drafting the bill, 1. Begin by showing the relations of the parties, and how they arose or were created, whether by contract expressed or implied, or by operation of law. 2. Then show how and wherein the duties arising from those relations have been violated by the defendants, and the extent of the injury resulting to the complainant from such violation. 3. If there are other parties, secondarily liable to complainant by reason of the other defendant's primary liability, show how and wherein. 4. If any specific property is sought to be attached, impounded, recovered, or secured from removal or alienation, so state, specifying the property so as fully to identify it, and giving, with particularity and precision, the grounds for this procedure. 5. If the defendant is doing or threatening any act likely to result in irreparable injury to complainant, or any act contrary to equity and good conscience, detail such acts, and show how or wherein they will work irreparable injury or gross iniquity. 6. If there is any matter connected with, or growing out of, the foregoing matters, necessary to be brought before the court to enable it to make a complete decree and determine the whole controversy, here bring forward such subordinate matters, and show their connection with the principal matters in dispute. 7. If any preliminary relief is needed, any injunction, attachment, or receiver, so specially pray. 8. Then pray for specific and general relief. 9. Aver that this is the first application for the extraordinary process prayed. And then 10. Sign the bill, and have your client make proper affidavit to it, if necessary. All of this will, perhaps, be better understood by reference to the following. General form of bill where relations exist. For address and caption, see ante 1 SS. 164. The complainant respectfully shows to the court that at a time stated, certain specified facts existed, whereby arose between the complainant and the defendant certain relations, stating the relations. Roman 2. That, as a result of the aforesaid relations, certain specified duties or debts were imposed on, or incurred or assumed by, the defendant, and certain specified rights accrued to the complainant, setting forth these duties or debts and the rights claimed with definiteness. Roman 3. That the defendant has violated his aforesaid duties to complainant, and has withheld from the complainant his just dues or rights in the premises, showing wherein, with clearness and particularity. Roman 4. That, as a consequence of the preceding facts, the complainant is entitled to relief, and he therefore prays 1. For proper process to bring the defendant before the court. 2. For the particular relief he deems himself entitled to, and 3. For general relief. 169. General form of a bill where no relations exist. Bills of this kind are generally filed to assert rights to, or to secure protection for specific property, real or personal, as in a bill. 1. To assert title to, or interest in, land or personalty. 2. To protect or preserve land or personalty. 3. To remove clouds on title. 4. To stay waste, prevent trespasses, and inhibit irreparable injury. 5. To enjoin or abate nuisances, and the like. These bills also lie in many other cases where injunctions are needed, as in 1. Bills quia timit, 2. Bills of peace, 3. Bills to prevent a multiplicity of suits, and indeed in all other cases where the suit does not spring out of some contract, express or implied, or of some relation between the parties, but is based on some right of property in the complainant, and some actual or threatened violation of that right by the defendant. The following general form will aid the draftsman of such bills. General form of bill where no relations. For address and caption, see ante 155. 164. The complainant respectfully shows to the court 1. Here allege complainant's title to the property or other particular right, which he seeks to assert or protect, describing the property or right, so as fully to identify it, and if it be land, give the boundaries and location of the tract. 2. If said title or rights are evidenced by any writing or other muniment, so state, giving its date, and otherwise describing it, and making it an exhibit to the bill. 3. Show when, wherein, and by which of the defendants the complainant's rights have been interfered with or denied, or his said rights or property injured, or threatened, or his possession, or use thereof interfered with or denied, stating clearly the time and main facts constituting the wrong complained of, and necessitating the application to the court for relief. 4. If any of the defendants, especially defendants under disability, have rights or interests similar to those of complainant, and are entitled to similar relief, state, in a general way, these facts. 5. If necessary to set up any special equity, or to relate any special atrocities, or gross misconduct, or other iniquitous conduct of the defendants, in order to emphasize the complainant's wrongs, here set out such matters with reasonable certainty of time, place, and circumstance. And if there be any grounds for an injunction, attachment, or receiver, here state them fully. 6. Here pray for the necessary process to bring the defendants into court. And if any injunction, attachment, or receiver is necessary, or guardian ad litem, or administrator, pray therefore with particularity. 7. Here specify the particular relief desired, conforming your prayer to the facts alleged, praying in the alternative when necessary and proper, and praying also for general relief. 8. Show that this is the first application for the particular extraordinary process prayed, and if not the first, explain and show why such process should now be granted. 9. The bill must be signed by counsel, or by the complainant in person, and if any extraordinary process, or any interlocutory order, not of course, is applied for, the bill must be sworn to, and a proper jurat attached. 170. Character of the allegations in a bill. In drawing bills, Remember that the more extraordinary the relief sought, the more specific must be the allegations. In a bill to collect an ordinary debt, without extraordinary process, general allegations showing that the defendant is indebted to the complainant may suffice. And in an ordinary ejectment bill, general allegations of ownership by the complainant and of wrongful possession by the defendant may sustain a suit. But general allegations will not be sufficient when the bill seeks 1. to attach property, or 2. to have a receiver appointed, or 3. to obtain an injunction, or 4. to set aside a conveyance, a settlement, or a contract, or 5. to reform a written instrument, or 6. to sell, reinvest, or expend the property of minors, or 7. to set up a resulting or constructive trust, or 8. to have a specific performance of a contract, or 9. to obtain a divorce, or 10. to obtain a new trial at law, or 11. a review of a former decree in equity, or 12. where in any case fraud is charged, or a trust is set up. In such and all similar cases, the facts must be set forth with such distinctness, precision, and particularity that the court may clearly see the equities complainant is seeking to raise and have enforced. The chancellor should not be required to grope his way through a misty indefiniteness of statement, or be left in a labyrinth of inconclusive averments, or be forced to draw deductions from unstable and uncertain premises. The facts on which the alleged equity is founded should be set forth with such orderly and specific particularity, and with such a well-defined clearness of statement and certainty of averment, that the equity alleged will stand forth in the light of the facts with statue-like distinctness to the eye of the judicial mind, and not be a mere misty mental exhalation floating indistinctly amid the shadows and darkness of indefinite, inconclusive, and confused general averments and semi-averments, whose meaning and bearing are inexplicable. A party should not undertake to drag a defendant into a court of conscience, unless he 1. has a good cause of action in fact, and 2. has that cause clearly and sufficiently set forth in his bill. Neither information alone, nor mere information and belief, will suffice to sustain a prayer for relief. The complainant must make positive and direct averments, allegations, and charges that the facts are so and so, and that the defendant has done so and so, using his information merely as the ground of his charge or averment, and to show that the fact alleged is not based on the direct personal knowledge of the complainant. 171. How parties should be described. Parties, both complainant and defendant, should be described by their proper names, if known, always giving their first name in full, and never using the initial of their first name, unless their first given name is unknown and cannot be readily ascertained. If, however, a defendant is sued upon a written instrument, he may be sued in the name and description used in the instrument. If the name of the defendant is unknown and cannot be ascertained upon diligent inquiry, the bill should so allege, using the statutory form, and setting forth in the bill clearly the character in which he is sued, and his title or interest in the subject matter of the litigation. If the name of any party is a common one in the neighborhood, so that the sheriff may not know which one of two or more with the same name is intended, the bill should use some method of designating him, adopting the particular designation, if any, used by his neighbors. This may be of great importance, and may prevent trouble not only in serving the subpoena, but also in enforcing the decree, and in divesting and vesting title. 172. How lands should be described. Every bill that seeks the sale, partition, or recovery of land, or to clear the title to land, or to redeem land, or to specifically enforce a contract in reference to land, or that, in any other way, seeks to effect the title or possession of land, or any interest therein or encumbrance thereon, should describe the land by location, corners, courses, and distances, or other appropriate description sufficient fully to identify it. A reference in the bill to exhibits, while sufficient in law, is a loose and dangerous practice, especially if the exhibit has not been registered. Exhibits are liable to be lost or mislaid, and are sometimes withdrawn by leave of the court, in which case the description may be lost. Unless the land is adequately described in the bill and in the decree, the purchaser may be greatly embarrassed in asserting his title to definite boundaries, and the reputation of the solicitor, clerk, and chancellor for accuracy and business capacity may be greatly impaired. 173. Some miscellaneous suggestions. In drawing a bill where the parties are numerous, always leave in the caption 2 or 3 blank lines for the insertion of additional complainants and defendants. Because, while drawing the bill, you will often find it necessary to make additional parties or to make other changes in the parties, and these blank lines will prove serviceable and obviate the necessity of inartificial and oftentimes illegible interlineations. It must be kept in mind that, whenever a bill sets forth facts on the strength of which 1. Process by publication, 2. An injunction, 3. An attachment, 4. A receiver, 5. The appointment of a guardian ad litem, or 6. Any other extraordinary, preliminary, or ex parte process or order is prayed or sought. It is both a pleading and an affidavit, and must therefore be verified by the oath of the complainant or of someone else acquainted with the facts. If you have no need for the evidence of the defendant, or have not full confidence in his veracity, do not fail to waive his oath to his answer in drawing your bill. If, however, there are material facts exclusively in the personal knowledge of the defendant, or if he have material papers in his possession or under his control necessary to your client's success, you may require an answer on oath, and may incorporate in your bill searching interrogatories to be responded to by the defendant in his answer. But remember that you cannot force a defendant to discover if you waive his oath to his answer. Avoid all scandal, all impertinence, all literary allusions, all poetic displays, all indelicate statements, in short, all unnecessary allegations. After the bill has been drawn, add a half sheet, 2 pages of blank paper as a back to the bill. It will be found convenient to write a fiat on, or an order appointing a receiver, and will give the clerk room enough to make his endorsements.